investigation by CBI with regard to the creation of supernumerary posts is imperative to bring to light the nature and extent of the scam and persons that are involved therein. It is shocking that at the level of the cabinet of the state government, decision is taken to protect employment obtained fraudulently in a selection process conducted by the SSC for state-funded schools, knowing fully well that such appointments are obtained beyond panel and after expiry of the panel at the bare minimum. So the state cabinet, all departments, the entire memorandum which is prepared under the state rules. And I just showed to you, Lordship, there's a whole rule, there's a whole procedure, rules of business. The manual concerned of the state government under which cabinet notes are prepared, the administrative department, legal department, finance department are all consulted. And then a cabinet note goes up to the cabinet. So you are today saying, firstly, you get it wrong, you talk about illegal appointees. These are waitlisted candidates. Secondly, you today want to include criminality. And look at the dangerous precedent it sets that in every matter of these kinds, the entire cabinet, the whole process, everyone will be subjected to a CBI investigation. And most importantly, now see, my lords, in this background, paragraph 363, subclause 8, what is the direction given? The direction given is on page 363 at page 281, clause 8. Yes. CBI will undertake further investigations with regard to persons involved in the state government approving creation of supernumerary posts to accommodate illegal appointees. If necessary, CBI will undertake custodial interrogation of such persons involved. So, my lords, today, as your lordships are well aware, with the entire West Bengal Secretariat Manual, Chapter 6, rules of business, officers involved, departments involved, everyone who prepared this, including the state cabinet, the Advocate General, everyone will be subjected to, because the legal department, the finance department, everyone is involved. The approval of the legal department was taken. Everyone will be investigated by the CBI and if required will be taken into custody. And please see 118, what were the issues framed by this court in this matter, my lords, because your lordships asked me a pertinent question. Was it my instructions were never argued, never raised, not the subject matter, but the issues are called out in para 118, PDF 191, para 118. Yes. The previous enumerated rival contentions have been delimited. The following issues for consideration. Does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? Are the writ petitions maintainable at the behest of unsuccessful candidate writ petitions subsequent to the expiry of the validity period of the panel? Can appointments be made subsequent to the expiry of the validity period of the panel? Is the certificate dated so-and-so valid and admissible in evidence? Should the OMR sheets available in the seized hard disk be uploaded in the server of SSC to compare with final list stored therein? Should any reliance be placed upon the data stored in the seized hard disk to terminate the services of any employee? Can the recommendation be withdrawn by SSC without hearing the appointee? Whether revocation of recommendations under Rule 17 by SSC is valid or not? What relief or reliefs are the parties to the appeals and repetitions entitled to? My lords, with respect, apart from not being an issue, it's an extremely dangerous precedent that we are setting. What are we saying? That a court without an issue being raised, discussed, today orders a CBI inquiry if required with custodial interrogation, right going till the cabinet, with no proof, nothing, no suggestion of any criminality, and everyone gets roped in. Now, the whole cabinet process of decision making, my lords, in a parliamentary democracy, where do we go? Look at the far-reaching consequences of this direction which is being given. Apart from getting it completely wrong at the cost of reputation, talking about illegal appointees rather than the waitlisted candidates. where the cabinet note says there may be potential irregularities. Tomorrow, let there be no vacuum. Let people be taken from the wait listed, subject to outcome, subject to court. The SSC recommendation where they took permission of the court and where they wanted to apparently withdraw it, ultimately they refused them to withdraw and ordered a CBI inquiry. That also your lordship stayed. But this is much graver.
Yes.
So, Manoj, our respectful submission is that A, there was no occasion, no issue, no argument. But even on a principle of law, my lords, can such a far-reaching direction in the manner it has been given, we really be sustained, apart from the fact that here no one argued this point? I'm extremely grateful, my lords, for your lordship's kind consideration.
Who would be answering this petition?
My lords, our only other issue
Mr. Gupta, you are also on the same side?
Yes, Lord, I am for the commission.
My lords, our only other consideration will also be this, we lordships may keep in mind, that today it's not even CBI's case that 25,000 illegal appointments have been made. In one rush to cancel everything, my lords, creates and leaves the state with a situation where there's a huge vacuum, the teacher-child ratio, various other requirements under the Act, everything today goes for a 6 because suddenly en masse you say that 25,000...
That's on the second issue, whether segregation is possible.
Yes, that's a segregation.
Surely? Yes.
Yes. That is the other point
Okay.
which we are extremely concerned about. Very grateful.
Yes, Mr. Gupta.
Yes, my lord. Just 2-3 facts, my lord. First of all, my lord, the advertisements are given out, my lord, in 2016 for this batch of recruitment. There are 4 batches, my lord, 4 categories of persons to be appointed. First one, my lord, is class 9 and 10 teachers, assistant teachers of class 9 and 10, for which there is a rule of 2016. Secondly, my lord, teachers of 11 and 12, for which also there is a separate rule of 2016. Similar rules. Thirdly, my lord, Group C and Group D employees. Clerical and, my lord, subordinate. Most of the appointments, my lord, were completed in 2018.
Which is the fourth category?
Fourth category is, my lord, C. Third category is C. Fourth category is D. Group C, Group D. Clerical and subordinates. Non-teaching, yes. My learned friend is right, my lord. The third and fourth categories are non-teaching.
Yes.
Now, my lord, the appointments were given on various dates after counselling. My lord, mostly in 2018. And, my lord, they started working from 2018. In 21-22, my lord, the writ petition started coming in. By this time, the panels, validity of the panels had gone.
How long was the validity?
My lord, different dates, my lord, but 1 year with my lord, 6 months extension possible in certain cases, and my lord, in some there is no date, my lord. There is no, my lord, period mentioned. Now, in 21-22, my lord, these matters were brought in, my lord. There was a series of orders by the learned single judge some of which came to this honorable court, my lord. And one of those matters, my lord, one batch, by an order of 9th of November 2023, was, my lord, remanded, but not to the judge, but, my lord, to a division bench. Now, this did not cover, my lord, the whole batch of matters which were before the High Court. It covered some. This went to the division bench. The division bench has taken this, my lord, stand. This is the judgment which is before your lordship today. Now, my lord, this is the first appeal. The learned single judge did not dispose of the matters. Before that, your lordship said he will not dispose of these matters. It will be disposed of by division bench. So, my lord, the division bench disposes of this matter for the first time. And this, my lord, is the first appeal we have. Now, what is the substance, my lord, of this order? Your lordship has seen, my lord. First of all, the issues, if your lordship sees, and then I'll go to the directions. The issues are at paragraph 118, page 187 PDF. And, my lord, on the side, I'll put the answer also, my lord. Now, just see, my lord, does this division bench have jurisdiction to hear all the writ petitions and appeals listed before it? This was because this hearing was set up pursuant to a particular order of this honorable court, which dealt, my lord, mostly with the OMR sheet problems. And, my lord, the learned Chief Justice was directed by your lordships to place it before a bench. Now, the learned Chief Justice, my lord, passed an administrative order, and, my lord, it was placed before this division bench. The first contention was that this means that a particular batch is before this court, not everything.
The entirety.
Right.
Yes.
Well, I'm not making too much of an issue with regard to that, because the court said, let us treat it as a PIL. But, my lord, the result is, my lord, that there are many matters still pending before the single judge on this very batch. There are many matters pending before the appellate court, and there are several matters pending in this honorable court. And now, my lord, there is an actual conflict between orders of this honorable court and this judgment. My lord, I am only pointing out, my lord, that it is not possible, my lord, for this matter not to be heard out. Notice, my lord, and your lordship must hear it out, my lord. That's, my lord, where I am going now. Now, then, my lord, that was the first one. Answer is yes.